Hi, I'm John Hayes. I'm a certified bankruptcy specialist practicing in Southern California. I am a partner in the firm of Resnick Hayes Maradi, and I've also taught a basic bankruptcy class probably 25 times at the University of West Los Angeles School of Law. I thought what I would talk about today is try to give you like a 30,000 foot view of Chapter 7, what happens from beginning to end, just in a sort of a summary fashion, so you get the general idea of how a Chapter 7 bankruptcy works. I'm going to assume that the person who might be interested in filing qualifies to file Chapter 7. And I'm also going to assume that the person has no assets that a Chapter 7 trustee would want to sell and give the money to the creditors. You know, that's their job, really. As to, do you qualify? That's this thing called the means test. I did a little presentation on the means test a few weeks ago. You basically look at your income to see whether you qualify. Almost everybody qualifies. I'll leave it at that. As to assets that the trustee might want to be able to sell, literally in 97% of all cases, there's nothing for the Chapter 7 trustee to sell. That doesn't mean that 97% of everybody has no assets that the trustee could sell. People who have assets that the trustee can sell don't file Chapter 7 usually because they'd lose the asset, But from the viewpoint of the trustee, there's nothing to sell almost all the time. So I'm going to assume that's how it, in this hypothetical case that I'm going to tell you about, I'm going to assume there's nothing for the trustee to sell. All right, so the Chapter 7 case begins with a form called a petition. That's, it's like 7 pages now. It used to be 1 page when I started doing this a long time ago. It's 7 pages now. And then there's a whole bunch of attachments to the petition that we call the schedules. And literally, this petition and the schedules is about 60 pages. It's a pretty big job. The debtor, the person filing bankruptcy is called the debtor. The debtor will sign their name probably 11 times, I think, or maybe even 12. The forms are very important. They list everything the debtor owns, everything you own. That means your clothes and your furniture, and believe me, everything you own. There's about 10 pages listing the assets that you own, and you have to check none. You don't have any airplanes, you don't have farm animals, Then you list all of your creditors. You have to list what you are going to claim exempt. There's what we call the I and J, your income roughly for the month, your expenses for the month. There's a form called the Statement of Financial Affairs. That's 22, 23 questions. The forms are designed to help the trustee figure out whether you have anything that the trustee can sell. The forms are, nowadays we upload the forms with a filing fee. In the old days, meaning just a few years ago, you'd take the forms to the court clerk. The clerk would stamp filed. As soon as the case is filed, it's stamp filed, a case begins, and that's called the petition date, and it's a very important concept. A trustee is appointed immediately, and a judge is assigned to the case. The forms are sent to the trustee, to the Chapter 7 trustee. They're also sent to the Office of the United States Trustee. I don't believe they're sent to the judge. The judge doesn't look at your forms unless somebody asks the judge to look at your forms. So the U.S. trustee, they look at the forms because they're the ones that will bring a motion to the court saying you don't qualify if they think you don't. Otherwise, they don't have that much to do with your case either. The trustee is the one that cares, right? So the trustee gets the 60 pages of forms. The trustee reviews those forms. What you're looking for? Well, the trustee's job is to sell property that isn't exempt and give the money to the creditors. So what the trustee is looking for is whether you have anything that the trustee can sell. Some trustees do a little bit of independent investigation. Some trustees will look and see if your name is on title to any property. Some trustees might look up to see whether you own any vehicles that you didn't tell them about, but mostly the trustees look carefully at the forms. So about a month after the case is filed, there's this thing called the meeting of creditors. And the debtor must appear at the meeting of creditors. The trustee conducts the meeting of creditors. Most of the time, the meeting is 5 to 10 minutes. The trustee has looked at your schedules. The trustee can see you have nothing that the trustee can sell and give the money to creditors. 7 days before the meeting of creditors, you have to send the trustee your latest tax return. And the trustee will look at the tax return fairly carefully. I mean, if you have interest income on your tax return, you must have had a savings account or something where you were earning interest. If you have a mortgage payment, you must own real property or have some interest in real property. If there's business on your tax return, the trustee is going to be interested in that. Once the meeting of creditors ends, so that's about a month after you file. Once the meeting of creditors ends, most of the time, nothing happens after that. The system, the bankruptcy system, waits 60 days to see whether any creditors object to your discharge or to the non-dischargeability of a debt. If no creditors file a complaint complaining about your discharge, then the case will be closed by the court clerk. A notice will go out that your discharge has been entered, and the case will be closed sometimes a month, maybe even 2 months after the 60 days runs. So you file, and it's a month to the meeting of creditors. You wait 2 months, and then a month or two after that, the case is actually closed. So the case stays open, 4, 5, 6 months. One other thing that comes up a lot in Chapter 7s is this concept of a reaffirmation. It comes up most commonly with car loans. The Bankruptcy Code says if you owe money on your car, you have to reaffirm that debt, meaning promise the lender that you'll repay the loan in full according to the terms, or give the car back. If you give the car back, the debt's discharged the same with all the rest of the debts. If you reaffirm the debt, you have signed an agreement saying that I understand that I could walk away from this debt, but I choose not to. I will pay the debt according to its original terms. So that generally is done after the meeting of creditors, and it needs to be done before the discharge is entered. So I'm going to talk about that separately. maybe in one of the next few weeks, we'll talk about reaffirmations. But that's how a Chapter 7 works. It's a whole bunch of forms, and it's notice to the creditors. If you think there's some reason why this person shouldn't get a discharge, let us know. Otherwise, the discharge is entered automatically and the case is closed. If you have any questions, you can find our website, my firm's website. It's Resnick Hayes Maradi. The website is rhmfirm.com, Resnick Hayes Maradi firm.com. We're in Southern California. I don't practice in any other states. And I honestly, I can tell you, the bankruptcy code is the same in every state. But I'm not going to be much use to anybody asking me how does it work in Minnesota. You know, I don't know. But our phone number is 818-285-0100. By all means, leave comments if you'd like. I do try to answer those. Click the subscribe button, because I'm going to try to do one of these every week or so. Click the like button if you like us. So, you know, that helps us get the word out, if you will. And thank you for listening.